Mr. Belloc, I'm sorry to, something has come up that I have to deal with immediately after court, so I'm going to need to rise about 4 o'clock. Sorry about that, but I can't.
I'm endeavouring to go a bit more quickly given what you've told us, but
we might, it may be that we have to, it's just at 10:15 in the morning or something.
I appreciate it.
Right, yeah.
And we also thank you for dispensing with the gowns and reiterate that given how hot it is.
Yeah,
Thank you.
I think they put this on hopefully during the
And we've got fans.
the fan, yeah.
If this doesn't disturb you,
It's
then
just, you know, it is pretty shocking really, isn't it? That so much for the flagship court of the country. Said query, or maybe you're not allowed to say that anymore.
and my
Okay.
if it's okay with you, I have a fan, but if you don't, so I will try and speak more.
No, okay.
My lord, I wasn't going to go back to Svenska, the judgment, so you can put that away, but I am going to discuss Svenska. My lord, in Spain's submission, Svenska is important because it shows, and just so to remind you of what I'm trying to do here, I'm essentially trying to ensure or show you that the synthesis of what the cases show in paragraph 44 of Spain's skeleton are accurate and correct and apply here, and then I will take you to Article 54 and apply those principles. So, my lord, we say Svenska is important because it shows that the Court of Appeal was endorsing the view that even if the state had said it waived all immunity, it would not be enough to submit to the jurisdiction for the purposes of Section 2.2. And if nothing else, we submit and we can agree that Article 54 does not even say that. And I'll come back to that when I apply the learning from the cases to Article 54. Now, we say that realizing Svenska presents a problem, the ICL parties seek to distinguish it by arguing at paragraph 65.6 of their skeleton that Svenska relates to, and I quote, to private law commercial contracts with states, end quote. Well, the suggestion is that a different approach is merited to submissions and treaties between states. My lords, this is not persuasive, we submit. Commercial or not, they were cases against states just like the present case against Spain. Mrs. Justice Glossrich then was understood that her task was to apply the relevant learning under English law as to what qualifies as a submission to jurisdiction under 2.2. And that again is the inquiry you are being asked to undertake. The implications of what the respondents are saying is also bound, we would submit, to cause chaos or based on unprincipled distinctions. Because should it really be the case that there is a different test or approach to submissions to jurisdictions for the purposes of 2.2, depending on whether the alleged submission is in a contract or a treaty. And this is especially difficult to defend when one considers that Article 17.2, which I've mentioned before, defines an agreement as including, and I quote, a treaty, convention, or other international agreement. That signals that the SIA does not in fact envisage different requirements for a prior agreement just because it isn't a treaty, convention, or international agreement. So my lord, those were the two cases I wanted to take you through in detail. I now want to just take you through very quickly why the attempts to distinguish the other cases in our paragraph 44 synthesis, you cannot distinguish on the basis that my friend tries to distinguish them. And my lord, if I can just show you what the ISL parties say, if your lordships can turn to paragraph 65D of the ISL party skeleton, 65D. That paragraph seeks to distinguish 65D, the two cases, Serkis and Petro Poroshenko, and Nogueira de Barros in Federal Republic of Brazil. My lord, Serkis and Poroshenko is a recent case in which the law and submission waiver has been set out. And the ISL parties try and distinguish this case by saying it is about diplomatic immunity and not relevant to this case. My lords, that is wrong. Part of the case on immunity in that case was that Ukraine, by a letter, had submitted to the jurisdiction of the English courts. This brought into play Section 2.2 and the question of whether there was a prior agreement. That is precisely the same question at play in this case. And my lords, in that context, at paragraph 115, Mr. Justice Carver repeats that a waiver, I quote, must be expressly and unequivocally communicated, and that this followed from the English and international law sources. And that's all I wanted to say about circus, my lord. So the attempted distinction doesn't work. The second case that the ISL parties try and distinguish out of the summary from Spain is the Newey Brazil case. My learned friend in his skeleton says that this can also be distinguished and limited to its own facts regarding employment contracts of embassy staff. Now, it did not consider the effect of a multilateral international treaty, and this argument is based on the premises that, again, different rules apply to a qualifying submission depending on the underlying instrument in which they are contained. My lords, as I've already explained, there is no reason in principle or authority that supports that view. The question each time is whether there is a qualifying submission for the purposes of 2.2. And when you read that case, and I don't need to take you to it, the opening paragraph of De Barros' case explained that the question they were addressing was whether there was a prior agreement under Section 2.2. And that's really the question that you are being asked to address as well. And also, can I then come back to Spain's synthesis of what we say is a test for a qualifying submission under 2.2, and that's at paragraph 44 of Spain's submission. Well, I'd invite you to turn to it. Excuse me. That's paragraph 44 of Spain's skeleton. My lord, just, you see it there. A submission to jurisdiction must be express, unequivocally communicated to the courts, and cannot be readily implied. It must be communicated by the state itself. As immunity belongs to the state, only the state can submit to the jurisdiction. A submission to jurisdiction cannot be general but must be precise, such that simply saying immunity is waived is not enough. Not all waivers equate to a submission to jurisdiction. What is needed is a specific submission for a particular complainant on a particular complaint. My lord, I want to now apply...
Just
sorry,
before you do,
course,
what does
yes.
44.4 mean? I mean,
My lord,
suppose that the treaty said unequivocally each contracting state, no, all contracting states submit unequivocally. I mean, is that not... What does particular complainant and particular complaint mean? You presumably have something that deals with things generically.
right, my lord. I would submit that it could be, for example, in an arbitration, in a clause in a contract, which is between two parties. You would then say that any disputes under this particular contract against this party are covered. And I would, so it would have to be a submission that generally defines who the complainant is and what the particular in relation to a class of complaints and in relation to a class of complainants. So it can be saying that it's a class of complainants does not violate the idea that it has to be a particular complainant.
So if Article 54 said the contracting states will submit to the recognition of awards, that would be all right?
You know, if I may just do a quick, one of the difficulties we have is that we haven't got an articulation of what apparently the submission is. But if we were theorizing what it would be, it would have to be something, well, I'm loath to theorize, but it would have to be something like that we submit to the jurisdiction of each of the contracting states for the purposes of the recognition of an arbitral award. I
mean, you say
yeah.
we.
I say, well,
It would be enough if it said all contracting states submit.
Perhaps, my lord. To be fair, I haven't thought about exactly how it'd be articulated because I was hoping the other side would, but I can think about that and come back to you. But it's certainly the case. What I would say is that you would need, it could be a general class and a general complaint. But of course, the difficulty here, my lord, if I may say so again, is that we, in a treaty such as that you have before you, we say that the submission or waiver, as it were, the root is the arbitration agreement, which will always be specific. My lord, can we look at Article 54 and then apply the learning from these cases? My lord, you could either go to the annex of the 1966 Act or the convention itself. The convention is in bundle 7, tab 100.
Is it right that the only authority for the proposition there has to be a specific or a particular complaint from a particular complainant is the employment tribunal case?
My lord, that's a very good question. You've just reminded me that I wanted to take you to Mr. Justice Dias's decision. It's not exactly in those terms, but there is a level of specificity that she suggests which is consistent with that, but it's not exactly the same. But perhaps I can just take you to that. My lord, it's sorry, I just had it's volume 5, tab 61.
So what are we looking at?
My lord, we're looking at Mr. Justice Dias's decision.
Yeah.
What's this
Right.
skeleton? I think was written before that decision came out.
What paragraph?
And it's paragraph 68. It's not the same as 44.4, but there is a level of specificity which is worth bringing to your attention. Paragraph 68. You see that, my lord? It's not the same, so I'm not suggesting that this is the same as the employment tribunal.
The difficulty with this, isn't it, is that section 17.2 makes it plain that an agreement may be in a treaty or convention.
Yes.
And the treaty or convention isn't going to deal with one specific set of proceedings.
Right. My lord, it's my lord, I could go away and think about it, but maybe perhaps the question is, certainly, if you're asking me whether one could have a multilateral treaty in which there is could there ever be a submission in a multilateral treaty, I would have to say potentially yes. And you're saying, how can that ever be specific enough to satisfy these standards? Is that?
I'm sorry, I thought what we were talking about was agreements under section 2.
Yes.
And you rightly pointed out to us earlier that section 17.2 makes it plain that references to an agreement include references to a treaty, convention, or other international agreement.
Yes.
Now, I thought it's obvious that those types of instruments are not relating to a single dispute.
I know it's not
specific.
It's not always obvious, but I suppose there could be.
Well, in the main.
Perhaps, my lord.
But if you go back to section 2,
Yes.
and say, state most in this after the dispute giving rise to the proceedings has arisen, well, that's obviously is focusing on specific proceedings, or by a prior written agreement, and then, as my lord says, that includes a treaty or convention or other international agreement. But there's nothing in those words which limits that part of it to some specific set of proceedings or a specific claimant.
My lord, I agree. And what I agree that those words, if you just read those words, they don't suggest that. And that's why we have to look at the cases. And you may take the view that out of the 4 principles that we've put forward, the last one goes too far.
Okay. Good.
My lord, I just wanted you to have Article 54 next to you while I take you through applying the test. And also, against the background of the cases I've taken you through and the synthesis and what Lord Goff said, let me just summarise why we say Article 54 is not a submission to jurisdiction under 2.2. My Lords, based on the majority and certainly Lord Goff's view in Pinochet, and this is the first point, the alleged submission in Article 54 is at best, we say, implied. And that, it is common ground, i.e. if it's an implied submission, does not meet the test of 2.2. Article 54 on its terms, we submit, only speaks to and obliges the contracting state with respect to its own courts. In other words, it speaks to Spain's obligation to recognise the award in its own territories. It doesn't say anywhere that Spain has agreed to submit to the jurisdiction of any court where the award may be enforced. Article 54.1 does not even speak about immunities, and in that regard is weaker, we submit, than the provision in Svenska that was considered insufficient for 2.2. So, my Lords, Article 54.1, and indeed any of those provisions preceding it or after it, do not come close to being, and now I'm applying 44, an express, unequivocal statement by Spain submitting to the court of this country for the purpose of the claim by the ISL parties based on their award. Now, my Lord, sorry.
So your starting point is a point of construction, is it?
It is, my Lord. My starting, yeah.
You say each contracting state is only agreeing for itself and not saying anything about what any other contracting state can do.
Yes, my Lord, but if I may, you've probably already got this, but my first point is that properly characterised, this is an implied submission at best, and that is, everyone agrees, is not enough. But if you want to then analyse it against what is required, then as you say, my Lord, it's a point of construction. Yeah.
And I follow the point of construction. If the point of construction were determined against you, then might it not be an express provision? Because then every contracting state would be agreeing that every contracting state shall recognise an award. Now, it doesn't use the word submit, but it is an express agreement on that thesis that each contracting state is to recognise an award.
As if it were a final judgment.
Sorry, I will. Yeah, I will. But that's why it took some time to take you through Pinochet. It's one thing to agree that you will recognise in the same way that you will prosecute torture, but it's quite another to say, well, that must mean that you have submitted to my jurisdiction, and we can't. I'm sorry, I keep belabouring this point. One has to see this in context. That doesn't mean that the whole system falls down, because really the way through immunity is the arbitration agreement. My Lord, as I said, Spain's view is that the words are clear and there is no need to resort to the travaux. I appreciate that the travaux has been discussed in some detail in the submissions and judgments. To avoid duplication, Spain is content to adopt the detailed submissions made by Zimbabwe on the travaux, but I would just make 3 short points on them. My Lord, it seems to be agreed by all the parties that nowhere in the travaux was adjudicative immunity discussed. It is also agreed, and the travaux shows, and my learned friend Mr. Moulin will show this to you, that the main purpose of Article 54 was to facilitate claims by states against investors. The operating assumption of the drafters was that states would comply, and if they did not, the proper route was an interstate diplomatic protection claim, potentially before the ICJ. Much is made of Article 55 and how it preserves the national laws on execution immunity. It is said that this implies that the rule on adjudicative immunity were therefore not preserved. So if it's A, then it must mean not A. But there are 2 points to be made here, my lords. First, the travaux shows that this was inserted, and again, Mr. Moulin will show you this, for the avoidance of doubt, and you'll see that in Zimbabwe's supplementary skeleton, paragraph 63. Second, the positive consensus that execution immunity was untouched does not mean that adjudicative immunity was waived. It is quite possible that as the Travaux seems to confirm, the subject was not discussed. At most, it shows no consensus on the matter. And I just remind your lordships here, why I spent some time on it, about the dangers of trying to read in to a treaty words, given the complicated background and horse trading that goes on in concluding a multilateral treaty. My lord, there is a sense in the respondent submission, one may call it an alarmist reaction, that we say doesn't reflect reality, but I've already mentioned that, which is if you don't find a submission, then the whole system falls down. Well, that's not correct. As Professor Schroer's writings show, and what the Supreme Court relied on in nuclear, and what I have emphasized, the way through immunity is not the submission in 2.2, it's the arbitration agreement.
Can we just come back to the words?
Sure.
Forgive me. I feel as if we keep every time we come to them, we keep sliding away from them.
Right.
Not a criticism, but I just really would like to get to grips with it, if
Yes.
you don't mind. And you say that each contracting state shall recognise an award rendered pursuant to this convention. It means simply that Spain is agreeing to recognise an award in Spain.
Yes, my lord, and it is subject, and I suppose what I'm saying is that it says we are undertaking to recognise the award, treat it like a judgment, subject to the rules, and that's why I took you to those other authorities, which said that the step 1, before you get to 54, is a jurisdictional question, the immunity question. So subject to the rules of immunity.
Yes, but let's come back to the words.
Yes, yes.
Each contracting. Now you say that means Spain is agreeing to recognise an award in Spain. I have no problem with that. But the question is, who are they agreeing with?
It's an agreement, my lord.
They're agreeing with the other contracting states.
Yes.
So that completely undercuts your argument that Spain is only agreeing to recognise in Spain, because it also means the United Kingdom is agreeing to recognise in the United Kingdom.
My lord, it's that it also means. I'm saying first that it also means, because it doesn't say it, it necessarily, the deductive part, means that you are implying into this a submission by all the other states that turn up to the Spanish court and saying that must mean that all you contracting states are submitting to the jurisdiction. I think that's where the difference is between us, my lord.
But it's not implication. I mean, the argument against you is it's not implication, it's just the proper construction of the provision in its context as a provision in a treaty of which both the United Kingdom and Spain are signatories. Because the effect of your argument, if it's just restricted to Spain and it's not also the UK, is that the UK is in breach of its obligations under this treaty as a consequence of if your client is right.
My lord, just a few things. My lord, the reason why I took pains to take you through the Pinochet case was that the same sort of point was made there, and in a majority, their lordships did not think that there was an express agreement there submitting to the Torture Convention.
That was a very different treaty, looking at very different circumstances. Here, you're looking at arbitration awards between the state and a third party. And that is the context in which Article 54 is drafted.
My lord, you say it's a different treaty, but it is important that when one, for example, looks at the VCLT, there's no distinguishing about what kind of treaties there are when it comes to interpretation and applying the rules of construction. And when you look at the paragraphs I took you to, that same reasoning applies irrespective of whether it's a torture convention. Arguably, there was a real motivation in the House of Lords, given torture, given the obligation to send torturers back or prosecute them, to say, well, that necessarily must mean, if you've agreed to do that, that the person who's committed that torture can't claim immunity. We're now talking about arbitration awards, and it's the same structural argument.
The wording is completely different, isn't it?
But my lord, the structural argument is the same, which is if you have an obligation, if you've undertaken an obligation to do X, which in that case is to prosecute or extradite, that must mean that you have also assumed that the state cannot raise a jurisdictional argument. And I'm saying the same thing as here. If you've agreed to treat an arbitral award as final binding and as a judgment, that must mean, or as the respondents in the Board of Timbers case put it, inherent, because you have to say inherent. It doesn't say submission. it's inherent in that you, the state, has submitted to the jurisdiction. And I suppose we're going
We're
around
not talking about here waiving immunity.
submission, my lord. Yes.
We're not talking about immunity. We're talking about, is this an agreement to submit to the jurisdiction
Yes.
of, in this case,
Yes.
the courts of the United Kingdom in relation to registration of an award. And this is an express agreement between Spain and the United Kingdom that the United Kingdom will recognise an award against Spain pursuant to this convention.
And my lord, I think the issue, the difference is there. My lord, your lordship believes that it's express, and I've tried to show you why, if Lord Gough was here and looking at this, based on what I can see, he would not treat that as an express submission. It's inherent, and ultimately that's what it is. If you see this as an express submission, then of course it is what it is in terms of the tests that apply. And that is a debate. As I said to you at the very top of my submissions, the core, the essence of the dispute is, we say that's implied. Our friends opposite say that it's express.
Yes, I really do understand the point. I'm just trying to drill down into the actual words used.
Yes.
Because my lord said, on a true construction, you accept that one's not limited to, one must be able to look at the express meaning as a matter of proper interpretation.
Yes. All right, my lord. And what I've tried to, well, I suppose you will find when I take you to the High Court of Australia case, you'll see the approach they've taken, which is to say that express must necessarily mean some form of implication. And that allows them to take the road to say that there is a submission here.
What I understand we're really looking at here, as you rightly say, and as Mrs. Justice Gloucester said, approved by the Court of Appeal, we're not looking to find a waiver of immunity. We're looking to find a classic submission to jurisdiction clause.
Right. My lord, what we were trying to take away from that is, at least in my submission, we see even a statement that says, I am waiving immunity as being stronger, because at least they're talking about immunity, and there is some broad sense that there is an aspect of waiving and not raising the immunity argument as being a stronger statement than what you see in 54.
Why should it be taken to be stronger? I mean, it's dealing with something that's different.
My lord, the reason why I submit that it's a stronger statement and one that doesn't obviously qualify even, is that if you put if you put a statement that says I waive immunity, you can arguably say there is some sense when it says all immunity that this state is saying that they don't want to raise immunity as a defence. That is a much more direct.
That's not what Section 2 is about.
No, I understand that, my lord, but what I'm trying to show is that statement that didn't qualify under Section 2 is stronger than the statement in 54, which doesn't even use the word immunity and doesn't even address the state that is before the court. It's talking about the state which is being charged to enforce.
Forgive me, I really struggle with this. Section 2 is nothing to do with an agreement not to assert immunity.
Yes, my lord.
What it's to do with is submission to the jurisdiction.
Right.
And that's the whole rationale of Mr. Justice Gloucester's decision, which seems to me to be unimpeachable given the wording of Section 2. It's to do the heading, submission to jurisdiction.
Right.
And what it says is, if you submit to the jurisdiction, you're not immune. So it's not, if you say you're not immune, you're not immune. And if you submit to the jurisdiction.
I understand that, my lord,
Yes.
but ultimately, at one level of generality, what one is testing when you're reading the words is, has this state agreed not to raise immunity as a bar to the claim, to the jurisdiction?
I just don't think, forgive me,
That's not the point. That's putting a gloss on it. I mean, it is what my lord put to you. This is a treaty between contracting states, an agreement between contracting states. Spain has agreed that it will enforce any award, it will recognise rather any award, ICSID award in its own country as if it were a final judgment. And it has also agreed that the United Kingdom shall recognise an award against Spain or against anybody else as if it were a final judgment of the courts of the United Kingdom. That's what's been agreed. And the only issue then is whether that amounts to a submission to the jurisdiction by Spain. It's got nothing to do with waiver of immunity.
Well, my lord,
It doesn't have to use the word waiver. Or
no, obviously they don't have to use the waiver. But what I'm saying, my lord, I agree that is the question. The reason why the waiver debate is interesting is one, people, even Lord Gough, used the word, but I think he obviously meant submission. Is that what we're trying to understand is whether the state has, through its words, submitted to the jurisdiction and will not raise immunity as a reason why this court.
No, the second half of that follows automatically from
I agree.
the statute.
Yeah, but
So we don't need to find any intention on the part of the state to waive immunity. All we have to find is a submission to the jurisdiction.
I understand that, my lord, but when you read the word waiver of immunity in a contract and try and use that as a submission, the argument there is that obviously the state is signalling here that somehow it doesn't want to raise the immunity crown.
But isn't this a distraction? Because that's not the words that are used in Article 54.
I agree, my lord, and that's my point. That if saying I waive all my immunity is not enough, then a clause and that's the state saying I waive all my immunity, then a clause that is not even authored as if it's written by, is not even talking about the state that apparently is submitting to the jurisdiction, doesn't even use the word immunity, is not as strong.
Why would it? The words that Mrs. Justice Gloucester regarded as submission were words that amounted to submission, not words that had anything to do with them. She said the words relating to waiver of immunity are not enough.
Well, yes, but the words there, the ones that she said in ANX were I submit. And it was a state saying I submit. This clause does not say, it's not a clause that says Spain. It's talking about what England is talking about in relation to the enforcement of awards in its court. And the different way of reading it, or the way we submit it the right way, is subject to the rules of immunity and jurisdiction. So the English courts are saying in 54 that I will treat the award as binding and I will recognize it as a final judgment, but subject to the rules on immunity. And as I showed you, that's exactly what Professor Schroer said, because he said that the ICSID Convention itself does not remove adjudicative immunity.
Can I just test how far you go?
Yeah, sure.
Suppose that Article 54 had said, instead of what it actually says, Spain agrees that the United Kingdom shall recognise and register an award against Spain. Would that suffice on your case?
Well, not on the test that I've said. Well, I'd have to think about that. I think, loath to give any statements on that. But it would certainly make my life and what I'm saying to you much more difficult, because that would be a statement by Spain saying that it submits to the jurisdiction.
Well, it wouldn't actually say that. I mean, that's why
Sorry,
I'm testing it.
Yeah.
It's the same wording. It's Spain agrees that the United Kingdom shall recognise an award against Spain as binding, blah, 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 blah. So it's the same wording, no mention of submission, but it is, on this hypothesis, Spain specifically agreeing that the United Kingdom specifically will recognise an award against Spain.
Apologies, I didn't understand your question. So almost as if Article 54 is written and someone's on the other side, Spain agrees with this in relation to it. Yeah.
Yeah.
I would submit no, my lord, because it has to be an express, unequivocal statement by Spain that it does submit. It's true that you can say it's 9 times, it seems very likely, but the reason why I took you through the cases I did was to show you that that's not enough. It has to be a very clear, unequivocal statement.
And would then such a clause mean anything? So
Well, yes.
if Spain, on this hypothesis, Spain says, I agree that the United Kingdom will register any award against Spain. Would that mean anything at all? Would it have any consequence?
Quite, my lord, exactly. So, my lord, Mikula shows that it does have meaning, right? Because in Mikula, 54 was the reason that drove the Supreme Court to say you can't stay registered award. That was nothing to do with immunity. So it does have a meaning. And that's what I said, that one mustn't get too alarmist about this, because there is the arbitration exception. And 54 does have a meaning, and the Supreme Court Mikula decision, if it stands for anything, it's that. My lords, can I then quickly just show you why, my lord, we say the judge was wrong on 2-2.
Can I just ask
sorry.
one further thing
Yeah.
about what you said? I think you said that it should be read as though it said subject to the rules of immunity.
Yes, my lord. That there's a preliminary first step.
So where would you insert those words?
My lord, I don't need to insert those words, because the obligation to enforce and recognise as a judgment can only be done if the court is able to exercise jurisdiction against the state. It's a preliminary first step that every court must ask itself: can I take jurisdiction here? That's why I took you to the Supreme Court authorities, and why I say even Professor Schroer understands.
But aren't we into a reasoning loop here? Because what we're addressing now is section 2, which says that if you submit to jurisdiction, there's no immunity.
It removes immunity, yes, my lord.
Yes.
Yeah.
So I'm not sure why we have to worry about immunity when we are looking at submission to jurisdiction. All we've got to look at is submission to jurisdiction.
Yes, my lord, but the preliminary bar, and how you, I'm perhaps misunderstanding your question and why you say there's a reason loop. All I'm saying, my lord, and what I said when I spoke about Mikula, is that the court has to first ask itself whether it has jurisdiction. Its starting rule is Spain is immune, show me an exception, and once it's cleared that, that's when 54, the province of 54 starts.
Forgive me, I don't understand that, because if 54 is being used as a jurisdiction agreement,
I'm not.
then you haven't cleared immunity before you look at 54. You have to look at whether or not it's a jurisdiction agreement.
Well, my lord, we say it isn't. That's our submission. Yeah.
Understood.
So,
What I find difficult about the approach is that if it's subject to the rules of immunity, how you can interpret 54 in that way when 55 expressly deals with immunity.
yes. My lord.
But why would you have 55 not including adjudicatory immunity if in truth 54 is subject to adjudicatory immunity?
Yes.
It just makes no sense whatsoever.
My lord, that's why I again took you through the Lord Goff's judgment, my lord, because just because it's something says A, not A is not true. So if it says execution immunity, which is what it's talking about, it doesn't mean that adjudicative immunity is not preserved. You would, I mean that.
Well, you say that, but that just seems to me to be
My lord, because
counterintuitive with respect.
My lord, it may be, but the Travaux don't support that. In the Travaux show that they spoke about execution immunity, and to then assume or say, well, if they talked about execution immunity and provided for it, that must mean that adjudicative immunity was not preserved. My lord, is a dangerous assumption because of the way treaties are negotiated and why I took you through the Lord Goff judgment. Now, you of course may not agree with that, but that's
I understand. I quite understand that, but at the end of the day, we have to we are involved in the process, are we not, of understanding, because Section 17.2 requires us to do so, combined with Section 2,
yes.
determine whether this treaty is a contract, an agreement, to submit to jurisdiction.
Quite right, my lord. That,
So we have, and I'm not sure that, obviously one has to understand the context of that contract, including the Vienna Convention and the authorities that you referred me to. But at the end of the day, we have to look at this to see whether or not Article 54 is an agreement to submit to jurisdiction.
exactly, my lord.
And that's all. That's the only question that
That's the only
on
question.
this limb of the argument.
Exactly, my lord. And what all I was trying to do, because of course the business of implying or express terms and trying to construe them each time is not always straightforward. And why I tried to make an analogy with the Lord Gough, I thought it would be helpful because, as I said to you, structurally it's a very similar argument, even if it is in the context of the Torture Convention. And why I was submitting to you that it's actually an implied term. But of course, you may disagree and agree with that High Court of Australia, whose decision I'm going to take you to very shortly.
Thank you.
Right, well, just on the judge, His Lordship, if we can just go to that judgment in tab 5, core bundle, core bundle. Tab 5 and my lord, it's in paragraphs 92 to 95 that His Lordship addresses the section 2.2 arguments. At paragraph 92, His Lordship describes the cases and principles I took you to as being of limited relevance. And say for one of the cases, which is Pinochet, he never names the cases and never explains why the analysis Spain put forward on each of them, and it was the same analysis I put forward to you, is of limited relevance. The one case, Pinochet, he does mention, it's explained very briefly, and the facts are cited, but again, no explanation of why that case is not relevant. It seems, His Lordship is saying, it is confined to its facts. But as I explained, my lord, this case and the others, whatever their facts, are directly relevant to the question you must answer, and as Lord Justice Phillips put it, is there a qualifying submission here for the purposes of section 2.2? Moreover, my lord, as I said, Pinochet speaks to the waiver argument or submission argument that is structurally, we say, very similar to the one the respondents are advocating, and so does deserve and merits attention. My lord, the learned judge does not engage in a detailed analysis of the wording of Article 54. Rather, when you look at paragraph 95, which is his conclusion, it's just driven by his earlier analysis about the effect of the 1966 Act and Nicola. And that is not correct for the reasons I gave. And as that paragraph shows, he is also driven by his sense that Spain's case on submission means that section 1.1 of the 1966 Act would only apply to awards in which the UK was a party. He says that is an absurd result. He would be right if that was indeed what Spain was advocating, but it is not. And the judge's conclusion here is a result of failing into the alarmist interpretation I mentioned earlier. Under Spain's interpretation, section 1.1 applies to all applications for the registration of ICSID awards against states, all states. All that Spain was saying and says today is that the award creditor could not rely on section 2.2 as an exception to remove the immunity that would otherwise apply because of 1.1. The only exception that applied in such a scenario is the arbitration exception in section 9. And this is a conclusion, as I said, which is consistent with Professor Schroyer. My lord, in the final part of my submissions, I wanted to take you through really the main foreign case that both Mr. Justice Fraser J. and Mrs. Justice Dias referred to, which is the High Court of Australia decision between the same parties. And my lord, you'll find that decision in Bundle Authority 6. Tab 89. parties, you have the decision. My lord, the High Court of Australia, as I call it the HCA, addressed the question at paragraph 7, whether Spain's agreement to Article 53 to 55 of the ICSID Convention amounted to waiver of Spain's adjudicative immunity under the Australian immunities legislation. The same question as you have before you, the same parties. The Australian Act is in the same bundle, but for present purposes nothing turns on the wording of that Act in the SIA. I will not therefore take you to it. I would just note the contradiction of the ISL parties commending the High Court of Australia decision, which applies immunities legislation to recognition proceedings, when its primary position is obviously opposite, that the immunities legislation doesn't need to apply. Now, my lord, if you turn to paragraph 18, you see there that the HCA is commenting on the statement in the Australian Law Reform Commission report that waivers must be express. In the HCA, you'll see already indicates that it thinks that that statement may be doubtful. Sorry, the extent to which this statement should be understood to reject the possibility of any implication of waiver or foreign state immunity from jurisdiction of the treaty is doubtful. And then the HCA then in paragraphs 19 to 23 analyse what the international sources have to say on the need for an express waiver. And you'll note heavy reliance is placed on Pinochet, and among others Lord Gough's judgment in particular, although the detailed analysis of this judgment and the underlying facts is not carried out. And at paragraph 23, you see the HCA concludes there is some ambiguity about what these numerous statements mean by their insistence that a waiver of immunity in a treaty be expressed. Part of the difficulty is a lack of clarity in legal discourse generally about what is meant by express. Properly understood, express meaning can include implications, which constitute the unexpressed content of a statement of term and which are identified by inference. My lord, I pause there just because I've said waiver a few times. The Australian legislation also says submission, but as I said to you, it's important that we do recognise that the words are used interchangeably sometimes by the cases. So that's paragraph 23. If you turn over to paragraph 25, you see there how the High Court of Australia translates this in the context of an international agreement. The insistence that the waiver be expressed should be understood as requiring that the expression of waiver be derived from the express words of the international agreement, whether as an express term or as a term implied for reasons including necessity. And then at paragraph 26, you see, it says that in this sense, the insistence by international authority that a waiver of immunity in an international agreement must be expressed is an insistence that any inference of waiver of immunity must be drawn with great care when interpreting the express words of that agreement in context. My lord, the HCA accepted that the approach it took was in line with the US approach. And you see that at paragraph 29. If I could ask you to turn to that, my lord. And then again at paragraph 74, you'll see the High Court of Australia say, paragraph 74, there is no real distinction between the US and Australian approach. And there is definitely a distinction, I would say, between the UK and the US approach, and I'll explain why in a moment. And then, my lord, if you
Can I
go
just
to
understand, is section 10.2 dealing with submission to the jurisdiction?
yes, yes.
No, section 10.2.
Huh?
That's in paragraph 14.
14. Submit to the jurisdiction.
Yes, my lord, sorry. Well, I was going to take you then, and apology if you're, I can't remember. If you go to paragraph 69,
69.
yes, my lord. And you see there the court's basis for holding that Article 54 contains submission or waiver, as they keep calling it. It is based on deriving that submission based on the effect of 53 and the preservation of Article 55 indicating or implying that adjudicative immunity was not preserved. It would be a distortion to hold an express waiver was needed before an award could be recognised. This is essentially, my lord, structurally the same point that the respondents make, and I dealt with earlier, which is that it would undermine 54 if you weren't to read that as also being a submission to jurisdiction. So, my lord, driven by its notion of the meaning of an express waiver, the HCA took the view that a waiver could be derived, the word it uses, from the meaning of Articles 53 to 55 of the ICSID Convention. And what I said earlier, rather boldly, but perhaps we'll see if it's justified or not. But just the first point, and I want to now explain why this is not an approach well, it's obviously not binding on you, but it's not one that we would commend to your lordships. The first is that it is not open to you, my lords, to adopt the US approach because it is much broader than what the highest courts of this land have told us is possible. Can I just show you the US legislation? It's in the same tab in tab 94. (3293), my lord, page 3293. My lord, the opening paragraph tells you what you need to know, in which a foreign state shall not be immune from the jurisdiction of the courts, and to be fair, the HCA does mention this, in which the foreign state has waived its immunity either explicitly or by implication. My lords, the cases here, including Lord Goth's judgment and the House of Lords, you see subparagraph A1 is very clear that an implied submission or waiver is not enough.
Sorry, I wasn't keeping up. Which?
Sorry, it's page 3293, my lord.
Yes.
1605
Yes,
A1.
Yeah, thank you very much.
And the HCA says that too, that it's in line with the US approach, and the US approach allows for an express or an implied waiver. My lord, there is an unexplained tension in the HCA approach. On the one hand, it says express can encompass meanings that are, and I'm quoting them, derived or inferred or based on implications. Yet on the other, the HCA says that it is in line with the US approach, which adopts a distinction between express on the one hand and implied waivers, and therefore clearly conceives of a category of implied waivers that is not an express waiver. The HCA never explains where implications being drawn can no longer be described as express and where something is truly an implied waiver. And I point that out not to make a philosophical point, but just to say that the HCA may not need to concern itself with precisely distinguishing that line because it adopts the US approach, which covers express or implied. So either way, you get through. But that is not the position of English law, where there is a demarcation between express and implied. And that is also not the position in international law, where a waiver of immunity must be expressed because the English cases refer back to the international law.
Forgive me,
Yes, sir.
aren't you slightly reversing the reasoning? I think what the HCA is doing is analysing the law as it applies in Australia and saying, contrary to what's stated, it actually aligns with the approach in the US. I don't think they're saying, I don't think they're drawing their analysis from the US approach.
My lord, it cites US cases. It says you can't distinguish between them at 79. I read
And
it.
what, sorry?
At paragraph 74,
Yes.
you see it says, as explained above, there is no real distinction between the United States provision,
Yes.
either expressed explicitly or by implication, or the Australian one. I think it's doing more than that, my lord.
But forgive me, just to understand the weight of this authority against you, we're talking about the highest court in Australia,
Yes.
which is interpreting a statutory provision which is in identical terms to the provision in this jurisdiction, and they do so on the basis of considering the case upon which you rely, Pinochet,
Yes.
in paragraph 22, and having done that, they come to the conclusion, which is exactly the opposite to what you are submitting to us, we should find.
My lord, you have summed up the burden on me quite well. I feel that burden, and I appreciate why I have spent a lot of time taking you through in much more detail than the HCA did, Lord Goth's judgment, and why I'm also telling you, my lord, that there are two things that one needs to, and I was going to come to this. The first is that the HCA is obviously influenced by, not just influenced by, but it says its approach is in line with the US approach, which is different. Secondly, my lord, sorry,
No, you carry on.
just one more point and then, and the second point to remember is, my lord, in the Australian legislation, there is no arbitration exception that would easily apply to an investment treaty case. So the burden on Australia, on Australian court, is to find a submission or a waiver through the submission provision. There is no equivalent to the 9(1) exception that we have here. And I don't think one should overlook that.
Right, sorry, I hadn't appreciated that.
My lord, the arbitration exception in the Australian legislation applies to commercial arbitration agreements, not the sorts of agreements we have, which is why in this case you would have noted the only basis on which it was being fought was a submission ground. Yes, sorry, my learned junior has explained that the reason why the arbitration exception is not being used in Australia is because the underlying transaction has to be commercial in nature, which is not the case in this dispute. It's an investment treaty claim about the regulatory action of the state, which is, as I said, which is why in this case there is no reliance on the arbitration exception. It's just the submission.
Is that section 17?
Yes. Yes.
Page 3320.
E. Yes, my lord.
3320.
Yes. Quite right, my lord. And on the face of the judgment, you can see there's no reliance on the arbitration exception.
And can you help me? Why is that limited to commercial?
My lord, it's the exercise of the supervisory jurisdiction of a court in respect of an arbitration, including a proceeding by way of a case state for the opinion of the court to determine a question as to its validity or to set aside the award. Yeah, it's about Australian seated arbitration, my lord. Yeah, which obviously the ICSID arbitration is not.
So this has the problem that was fixed by the amendment to section 9.
Quite right, my lord. Quite right, my lord.
So it's not a matter of commercial, it's a matter of domestic.
No, my lord,
Domestic.
sorry. That's fine. My lord, that was wrong. Yeah.
About 17(2)(b), wherever the award is made. That's concerning recognition. Doesn't seem to be domestic to me.
Sorry, my lord, I didn't hear you.
17(2). Seems to be dealing with recognition of awards wherever they're made.
That bit is commercial.
Well, that bit, my lord, I'm being told is the commercial part.
That is the commercial
Yeah.
aspect.
Yeah.
Right.
And my lord, as I said, that you can see from the decision itself, it's focused just on submission for that reason. And
I understand that might be a motivational factor, but it can't actually affect the correctness or otherwise of the HCA's interpretation of the equivalent of our section 2.
quite right, my lord. I see that. And
Full square, the High Court of Australia's interpretation of their section 10 is inconsistent with your arguments as to the interpretation of our section 2 in the context of Article 4.
quite right, my lord, it is.
And it isn't really the reason why the High Court of Australia is referring to the position in the United States is because it's obviously desirable that all jurisdictions, as far as possible, are taking the same approach to the to Article 54, which is why Australia, if not persuaded by the United States approach, is happy to see that it's the same. And we might take the view that it would be unfortunate if our approach was different to that taken in Australia and the United States.
My lord, it's also desirable to make sure that the test for a submission, which is a very consequential thing, is correct. And I would submit that the HA is going further than just saying we happen to observe that this is similar to the conclusions reached in the US. It is saying our statute, there is no distinction. There is no real distinction between the United States provision permitting express or implied waivers and us. I think that's going a bit further and putting itself in line to a statute that has a much broader gateway for removing immunity than our statute as interpreted by the cases.
But that's in the context of a court which seems to regard itself as applying Pinochet.
Well, but my lord, not with the detail that I've taken you through, with the greatest respect.
So the
All
High
they've
Court
cited
of Australia was wrong.
My lord, sometimes
Well, I think you need to say, if you're saying expressly...
My lord, I did say it was wrong.
They're wrong.
I do say they're wrong. Yeah. My lord, I opened with that. I said it's not, neither is it persuasive and it is wrong. But it's obviously not binding on you. So what I'm also trying to show you is why it's not persuasive, because it is, as I tried to say, it sounded very theoretical. But if you adopt that approach, that express can mean also implications, but there is something that is a pure implied waiver, where does that line stop? That's not just a theoretical objection. That is a cause for non-uniform application.
But I think we should make it plain. I don't think you're submitting, and it's certainly not something that we could say, that the High Court of Australia's decision is wrong as a matter of Australian law.
No, of course not, my lord. Of
No,
course not.
but what you're saying is that their approach
Doesn't read across.
doesn't read across.
Yes, my lord. I said not persuasive, yes, my lord.
Thank you.
My lord, I'm going to move on to ground 3, and I'm conscious that the Chancellor, my lord, you said 4 o'clock, so
4 o'clock. Yeah.
I will open with that. My lord, transcriber is requesting a short break, but I'm in your hand, my lord.
Well, it's up to the transcriber really if she needs a break. You'd like a break, would you? Okay, let's have 5 minutes.
Rise available.
Just as a reminder, the live stream's going to keep rolling the break.
Each contracting state shall recognize the result of the list of PIL. So there was any that's not it's already not and then enforce and create an
Is the audio working okay?
and Spain has a it's a normal because Spain has a great you will create an enforcement mechanism. I've therefore submitted to the legislature. You're not constraining you're very, very careful. And it's right. Your reaction, your reflexes are those of a commercial representation. Today in English law we're collapsing implication and interpretation and often get that very differently. Yeah. You cannot do that. And it's inevitable that because I agree to bring the mechanism, you agree that we should. It's not. Could be. Could be not. That's the answer.
Yeah, great.
And so they need to be given that. I know, but the problem is that everything you showed him is just trying to skirt around it, trying to get one point. He doesn't get the point. He doesn't want to get it. He doesn't want to get it. So we need to tell him and you the contract. It's not inevitable. The fact I agree to the mechanism that you agree to submit to it, especially when the reality is that you've got an obligation as a state public institution. There's another bit that comes from the no, I will say all not the truth. Yeah, and it's not the trouble. This is
The face of the face of the article.
this is the stuff. But
He used it himself.
oh my God, the next wizard. Put on your team.
I didn't realise they have said in their scope that I can said what he says.
Sorry, could everyone get to their seats again?
Yeah.
Not the real world.
Let's do a video 27.
Then I recall
Basically, PI commercial capital.
My last year I'm not surprised. She followed him around. When he walks, his arms move the same way. It's quite unusual. How does he stay upright? So literally what we're going definitely, isn't it?
It's a good one.
I can't believe you said that. I'm like next to my seat. What is it?
Is the courtroom ready? Court rise if able.
Yes, thank you. And also, I now come to the third and final ground of appeal, namely that the judge wrongly found that there was a valid arbitration agreement between the ISL parties in Spain, such that Section 9 of the SIA applied to remove Spain's immunity. My lords, as when I discussed and made submissions on Section 2, it would be helpful, my lords, if we can turn to Section 9 itself. And that's in the first bundle, tab 4. And it's page 55 of the bundle is where you find Section 9. As you read it, it says, where a state has agreed in writing to submit a dispute which has arisen or may arise to arbitration, the state is not immune with respect to proceedings in the courts of the United Kingdom which relate to the arbitration. This section has effect subject to any contrary provision in the arbitration agreement. And also, the Court of Appeal in Svenska has held that the reference to proceedings in courts includes recognition and enforcement proceedings such that a state would enjoy immunity in respect of recognition proceedings of an arbitral award based on a valid arbitration agreement with the aforementioned state. I won't take you to the passages, but you'll find them at paragraph 117 of the Court of Appeal decision, which is in the bundle A2, tab 28, page 972. It is not disputed that if there is no arbitration agreement, then section 9 does not apply, and that may arise for reasons including the arbitration agreement is not valid under its governing law, or because it was not binding on the state, or any other jurisdictional violation, which means that the party did not agree to arbitrate a particular dispute. In this case, we say that because Article 26 was disapplied, that may seem strange from a private law perspective, but it's a phrase we take from international law, and I will come back to it. There was, for the purposes of Section 9 of the SIA, no written agreement by Spain to arbitrate disputes with EU investors under the ECT. I will come back to that term, as I said, disapplied in the course of my submissions. Against that background, my submissions on Section 9 are divided into two parts, broadly mirroring the judge's reasoning and the respondent's arguments. In the first part, I will address the argument that the court is in fact precluded from even analysing Section 9 on the basis of Mikula and the ICSID Convention, since the inquiry about the existence of an arbitration agreement, it will be said, is an exclusive matter for the ICSID Tribunal or ICSID Denouement Committee. I will be brief on this because it was a subject of Mrs. Justice Dias's analysis, with which we agree and which my learned friend Mr. Mulan will address for Zimbabwe. And in the second part, and the one I will spend most time on, I will show you why, as a matter of international law, there was no agreement to arbitrate in the present case, and therefore the ISL parties cannot invoke Section 9, and the judge's finding otherwise is wrong. My Lord, that second part of my submission is the longest part, and it's really the distinctive part in this appeal.
Now, when you say international law, you mean the EU law?
My Lord, I mean
Well,
international
let's be blunt about it. You
Yes.
mean EU law?
My Lord, EU law is international law, and
Well, it may be international law, but there is an issue here as to what trumps what, if I can put it that way.
quite right, my Lord. But my Lord, I would at least ask you to be open to the idea that EU law works on two dimensions, both as on the international law plane, and I'll show you texts that do that, but both as what might be, say, a more downward-looking, non-international law basis that applies in the domestic arena.
Yeah.
And I will come to that, and I appreciate that as you put you've summarised what the debate essentially
Yeah, sure.
will be. My Lord,
saying
but I
that's-
just want to say what you raised a concern about the length of time that was allocated. That was a subject of a lot of submissions, precisely because in the other appeal, what they are saying is let's just ask the question whether Section 9 is even applicable. If you say it is, then we will go back and argue about jurisdiction, whether there's an arbitration agreement. Whereas in the Spanish appeal, in the Spain appeal, we have gone on and before the judge made submissions on why there is no arbitration agreement. And that really engages a very complex area of international law and a hotly debated one, which is why more time was allocated. That said, we will try our best to be as quick as we can to make sure that no one feels they don't have enough time. But I just wanted to make sure that you understood that, and that will be the major part of my submission. My Lord, just quickly on that first part, because as I said, my friend Mr. Mulan will address this, but it is important that you hear from Spain on it. My Lord, I just want to address here why we submit the judge was wrong to hold that the operation of the 1966 Act and Mikula precluded him from analysing jurisdictional question. My Lord, as I said, paragraphs 80 to 91, Mrs. Justice Dias addressed this argument and disagreed, holding that nothing in the self-contained nature of the ICSID or the wording of Section 9 precluded her from applying Section 9 to an ICSID award, to enforcement proceedings in relation to an ICSID award. We agree with her reasoning, so I'll just limit myself to 4 points. My Lord, first, we know from the Hansard extract I've taken you to that the drafters of the SIA expressly envisaged, we submit, the application of Section 9 to ICSID awards. And they in fact amended the wording to ensure that there would not be any conflict with the 1966 Act. And this, of course, would have been entirely unnecessary if, as a judge held that the respondents continue to argue, a court does not have to examine Section 9. Second, for the reasons I explained on ground 1, neither the 1966 Act or Mikela can be read as precluding the application of any part of the SIA to enforcement proceedings for ICSID awards. And third, at first instance, the ISL party's preclusion argument was based on issue estoppel, which is that the tribunal's own conclusion that the state agreed to arbitrate in the ECT is sufficient to meet the Section 9 requirement and cannot be reopened by the court. This estoppel-based argument is no longer, as far as I can see, being pursued by the ISL parties, but it is being pursued in the border timber appeal. And this may be because, as Spain explains in paragraph 33.4 of its skeleton, Spain's grounds for why there is no arbitration agreement, i.e. the argument that I will be making before you today, was not in fact considered by the tribunal or the annulment committee because of the cases on which Spain relies were not before them. Both, my lord, in the border timbers appeal, the estoppel argument continues to be made, and this, as I said, this may be because there is an overlap between what was argued in the arbitration and what will be argued under Section 9. Fourth and finally, the proposition that when it comes to Section 9, the court should not just defer to or be bound by the tribunal's own conclusion as to the existence of an arbitration agreement, we should analyse that question afresh. My lord, I would just say this, is backed by sound policy. Section 9.1 of the SIA is a mechanism that allows an English court to take jurisdiction over a foreign state, contrary to Section 1.1 of the SIA. In this respect, it displaces an immunity to which the foreign state is entitled as a matter of customary international law. If the English court errs in taking jurisdiction, it will place the UK in breach of its international obligations before the foreign state, and that is no small thing, as the ICJ's decision in the jurisdictional immunities case at paragraph 57 told us. The law of state immunity occupies an important place in international law and international relations. Once we remind ourselves of that fact, the reason why Section 9.1 of the SI is drafted as it is becomes clear. Given the ramifications of an erroneous finding, namely a serious breach of international law vis-à-vis the foreign state, the English court cannot simply take what the tribunal said at its word. It must investigate matters for itself and exercise its own forensic judgment. This requires a de novo hearing of the jurisdictional question. And it is based on these 4 points and those developed in our skeleton and in Zimbabwe's submissions that Spain submits that the judge was wrong in paragraphs 100, 102, and 107 to hold that the 1966 Act and the Mikela decision precluded any examination of the existence of the arbitration agreement under Section 9 of the SIA. And for those reasons, the ones that Mrs. Justice Dias and Zimbabwe will develop, we submit that Section 9 does permit a de novo examination of whether or not Spain had agreed to submit a dispute to arbitration. And my lords, it's to that second part, that inquiry, I now turn in the second and longest part of my submissions. My lord, we submit that the judge wrongly rejected Spain's case that as a matter of international law, there was no arbitration agreement in place to trigger the Section 9 exception. My lord, the common starting point is that as a result of the CJEU decisions in Slovak Republic and Acmea, what I will refer to as Acmea, and Moldova and Komstroy, known as the Komstroy decision, arbitration agreements allowing for investment arbitration between EU investors and EU states are disapplied. And the question, as the Chancellor put it, is, well, isn't that just an EU law conclusion? Is that an international law conclusion as well that binds us? And that is what my submission is going to be dedicated to explaining, that that can't be dismissed as just an EU law conclusion. My Lord, at paragraphs 57 to 67, sorry.
How, well, you'll no doubt deal with this, but how can that affect a decision by an English court in circumstances where we're no longer members of the European Union?
My lord, you'd be absolutely right if what I was advocating to you was that this is an EU law conclusion binding on you. But if I can persuade your lordships that this is
Why
actually
binding on us? Because it's an
international
EU
law, my lord, because that's the governing law of the agreement. And if I can show you that as a matter of international law, there is no arbitration agreement, it's been disapplied, then Section 9.1 is not triggered.
So there's an international treaty, the ICSID treaty, between countries, some of which are in the EU and some of which aren't. We've got another case before us which involves a country which plainly isn't part of the European Union, an international agreement pursuant to which there is an arbitration agreement. But there's a principle of international law, you say, that means that in the other case, there is no arbitration agreement.
Yes, my lord, and it's important to emphasize, and I'll do it again and again, the arbitration agreement here is not in the ICSID Convention, it's in the ECT.
No, I know it's in the ECT, which is also an international convention.
Exactly, my lord, and that governs the arbitration agreement. And it may seem bold and far-fetched, perhaps, my lord, when we put it like this, but I will explain to you that actually it's a very conventional international law analysis that leads to that conclusion, and one that's actually backed by some of the texts, leading texts that I will take you to. It's based on the subject of conflicting treaties and how the rules on treaty conflict are resolved as a matter of international law. Very unusual from a private law perspective, but not so under international. And I wanted to just take you through that, my lord, if I may.
Just remind me of one thing. I did look at the CJEU decisions, but obviously not carefully enough.
Yeah.
Is it crucial to them, in their own terms, that the claimants are EU-based?
My lord, yes, that's as far as our decision. This is just what we call the intra-EU debate. It's about intra-EU arbitration pursuant to an investment treaty, whether bilateral or multilateral.
And it counts as intra-EU if the claimant is EU-based.
Exactly.
So
Right.
if it were
From Kazakhstan and suing Spain under the ECT, this argument would not apply.
Yes,
My lord, as I said, the common starting point is what the CJE decided, that by virtue of two cases, and I'll come to that, the arbitration agreement that arises out of Article 26 was disapplied. My lord, at paragraphs 57 to 67, the judge covers the facts and reasonings of those decisions, that's ACME and Comstroy, in detail. And so I don't intend to go through them because what those cases decide is agreed. What their impact is as a matter of international law is not agreed. In short, what those cases say and are about is as follows. The question ACME addressed was whether investment arbitration commenced by an EU investor against an EU state under a BIT was compatible with two provisions of the Treaty of the Functioning of the European Union, which is Article 267 and 344. And my lord, I think it's helpful just to show you those provisions. They're in paragraph 31 of the judgment. That's, my lord, it's tab 5 of the core bundle.
Yeah.
We're looking at the judgment below.
Okay.
Paragraph 31, my lord. Just the two provisions I wanted you to note is Article 267. The Court of Justice of the European Union shall have jurisdiction to give preliminary rulings. Preliminary doesn't mean provisional, because what happens, as you know, and I'm sorry if I'm telling you something you already know, the court refers a question, the decision is made, it's preliminary to the final decision that comes back to the domestic court. The interpretation of the treaties, the validity and interpretation of acts of the institutions, bodies, offices and agencies. Then it carries on, and then you have Article 344 is an exclusivity provision under which member states undertake not to submit a dispute concerning the interpretation or application of the treaties to any method of settlement other than those provided for therein. My lord, the judge summarizes what the CJEU decided in ACMEA at paragraph 62 of the judgment. If I may take you to that. paragraph 62, my lord. Therefore, the CJEU made two fundamental points, in parentheses amongst other points. The first was to draw a distinction between commercial arbitration and arbitration under an international treaty provision. The second was to find that an arbitral tribunal, such as the one in that case, would or could be called upon to consider or rule on the applicability of EU law, yet was not competent to do that under the EU treaties or the law of the EU, because it had no jurisdiction to do that. Such a tribunal could not be regarded as a court or tribunal of a member state. This is a breach of the Article 344 in brackets I'm putting there. Nor could it make a reference to the CJEU for a preliminary ruling, a point made clear at 49 of the judgment in that case. And that was a breach of Article 267, I'm adding. This meant that treaty provisions permitting or establishing international arbitration for disputes involving member states was contrary to the EU treaties, and the CJEU therefore held that these were effectively invalid. Now, I would not use the word invalid. As I say, I'll explain why disapplication is a better word. But the point is that the ACMEA decision held that properly construed, Articles 267 and 344 of the TFEU precluded the operation of an arbitration agreement in an investment treaty, i.e. another treaty, for a claim between an EU investor against an EU state. My lord, it is also not controversial that ACMEA was not just deciding the case before it, it was and has been understood to be a declaration that all intra-EU arbitration agreements and investment treaties should be disapplied. ACMEA was about a bilateral investment treaty. There was a question about whether its learning also applied to preclude the operation of arbitration agreements in a multilateral treaty, allowing for investment arbitration between EU investors and EU states, such as the ECT, and Comstroy answered that question as yes. Article 267 and 344 meant that an arbitration agreement, like Article 26 of the ECT, are disapplied to the extent they allow for arbitration between an EU investor against an EU state. My lords, as I will show later in my submissions, what the CJEU said in these cases in respect of the conflict between the EU treaties on the one hand and the member states' obligations in the ECT on the other, and how it was to be resolved, is binding and represents an authentic interpretation, binding in international law. My lord, it is critical to understand, and I'll be repeating this throughout my submissions, that the CJEU is here speaking as a mouthpiece for all 27 states about their treaty relationships. We are not asking you to follow the CJEU as a supranational court whose decisions you must defer to. It has a very different function that is not normal for a court, and I'll come to explain that. My lord, if you can then turn to paragraph 87 of the judgment, you'll see that the learned judge agreed, and this part of his judgment is not being appealed as we understand it, that there is a conflict between the EU treaties and offers to arbitrate intra-EU investor-state disputes in the ECT. What the learned judge disagreed with, and the question that has been put to me, and what we are appealing, was the international law effects of that conflict and the way it has been resolved by the CJEU. My lord, it repays attention to read that passage, and I will come back to it in the conclusion. It's paragraph 87. I consider that there is a clear conflict between the EU treaties as their application to international arbitration involving member states has been decided by the CJEU and explained by Mr. Baloch in each, or more accurately both, of the ECT and the ICSID Convention. If intra-EU arbitration is contrary to EU law principles governing either primacy of the CJEU or EU principles generally, then this must and can only arise from the EU treaties themselves. I cannot see how it can arise in any other way. Therefore, if that is the case, there must be a conflict. That conflict, so there he recognizes the conflict, that conflict does not mean that the latter EU law principles, as enunciated by the CJEU, remove Spain from the ambit and scope of the ECT or from the ICSID Convention. Spain's arguments, as either amplified or further explained in submissions, including a letter to the court, was that there was a conflict between Articles 267 and 344 of the TFEU on the one hand, and Article 26 of the ECT on the other. In those circumstances, Spain maintained that this conflict should be resolved in favour of the articles of the TFU by what it called the treaty conflict rule of EU primacy. However, in my judgment, that is simply a different way of Spain maintaining that both the ECT and the ICSID Convention, both of which clearly have signatories who are not member states of the EU, should be interpreted by ignoring their clear terms regarding dispute resolution, in preference to granting the decisions of the CJEU complete primacy over those pre-existing treaty obligations of all states. I do not accept that is the correct approach, and I do not consider that such a result can be achieved by applying international law principles to conflicting treaties provisions. And we obviously disagree with the judge. And as I will explain, the international rules of treaty conflict do result in the conflict between the EU treaties on the one hand and the ECT being resolved in favour of Article 26 being disapplied, as between EU investors and EU states, and that this conflict, once declared, applies retroactively, at least from the date when the conflict first emerged, which is when the modern TFEU came into existence. And that adopting this approach does not mean giving precedence to the CJU as if it's an overarching court of appeal or Supreme Court, but rather to understand that the CJU doesn't just play a role as a court, but also is a voice for the states. So it's as if the states are saying, these are our rules of treaty conflict. My lords, there are a lot of points there, and we have taken the liberty to translate what I just said in a series of questions which are going to around which I will structure my submissions. My lord, there are 3 questions I would submit. The first is, and we can type these up, my lord, and hand them to you tomorrow when I continue. The first is, does the treaty conflict identified by the CJEU between the TFEU and the ECT mean that as a matter of international law, Article 26 is disapplied? And the second question, I'm not speaking too quickly, is at what point did the conflict arise? Is it retroactive or prospective from the date the conflict is declared? That's important because if it is not retroactive, then the disapplication occurs after the arbitration started, and then the arbitration agreement cannot be seen as inapplicable at the time at which it started, and therefore Section 9, one could take advantage of Section 9. And as I said, I'll explain that. That's the second question. The third is, can this reasoning apply? I think the Chancellor, Lordship, hinted at this. Can this reasoning apply to a multilateral treaty such as the ECT? Can it be said that the TFEU has primacy over intra-EU disputes under the ECT, but not those involving non-EU member states? In other words, even if I'm able to persuade you that there is an international law rule or treaty conflict which would allow the conflict to be resolved in favour of an arbitration agreement being disapplied, does that also operate? Is there anything that defeats that? For example, the fact that it's in a multilateral treaty context. And you'll see when I come to that, the answer is no. So those are the 3 questions, and as I said, we'll type them up if it helps. And also the first question, does the treaty conflict identified by the CJEU between the TFEU and the ECT mean that as a matter of international law, Article 26 is disapplied? My lord, I come to the point which I mentioned earlier in response to one of the questions from the beginning. We first need to briefly address a twin dimension of EU law as domestic law and international law. It is repeatedly said against Spain that its submissions seek to deploy EU law to trump international law. And this is improper because a state cannot use domestic law to trump its international law obligations. Article 27 of the BCLT is cited for that purpose, although its application is not explained. But the very premise of that argument is wrong and misleading. EU law generates both international law and domestic law, and the judge understood that, and his finding on this point was again not subject to appeal, but if I may take you to it, it's at paragraph 67. If you turn to the top of page 85 of the bundle, you'll see there is no doubt. Do you see that, my lord? There is no doubt that the law of the EU is correctly described as being international law, as self-evidently it governs relations between member states which have collectively entered into international treaty obligations under the EU treaties, including the TFEU. Those treaty obligations have international effect, and the institutions of the EU have primacy over domestic organs in certain important respects. However, as the claimants point out, this argument ignores the other aspects of international law that requires observance of existing express treaty obligations, and it also ignores the effect of Spain having pre-existing treaty obligations, the EU treaty. So what he's saying is that he accepts, and I'll take you to some text on that EU law also has an international law dimension, but he comes back to saying that does not mean that the conflict is resolved in the way that Spain says it does. But as I said, I'll come back to that. And all Spain's case is that where treaties conflict, as the judge accepted they did, you need to look at the international law rules of treaty conflict to resolve that conflict one way or the other. My lord, this point is well made in the context of EU treaties in a classic article by Professor Hartley, which I would ask you to open if I may. It's at bundle 8, tab 126.
Are you at some point going to take us to Article 26?
I am, my lord.
What's the date of this article?
I think it is 2001. You can check what it is. My lord, this article is about, well, I'll get you the date, my lord. I think it's
Actually, looking at your contents page, as you say, it's 2001.
Yes.
my lord, so the article is about the international law aspects of EU law, and after explaining that EU treaties and EU law are part of two legal systems, the EU and international law, which you'll see at internal page 17, he goes on to discuss some of the consequences of EU law being international law. And that you will find at internal page 22 under the heading of conflicting treaties. The final problem to be considered, and this is page 22, is what happens when there is a conflict between two treaties, one being a community treaty. We assume that both are valid and in force, and to the extent that their provisions are compatible, there is no problem. Both apply. We are concerned with conflicting provisions. By definition, both cannot apply. Such conflicts must be resolved by international law. And he speaks about the complexity of the rules because, and as I will show you, the rules in the VCLT don't always apply. And again, I will take you to that. So my lord, the next question is, what rules of conflict as a matter of international law apply to resolve the conflict between the TFEU and ECT? And I want to address this point by giving an overview on how treaty conflicts work and then explain the specific treaty conflicts rule at play in this case, which is the rule of EU primacy. Under this rule, the rule of EU primacy, treaty provisions conflicting with EU treaties are disapplied, and I will call this rule of primacy, I will call this a rule of primacy for short. My lord, there are multiple places where such conflict rules are to be found. They can be found in the VCLT, one or both of the conflicting treaties, or other pronouncement by the conflicting treaties, or other, or via designated bodies such as a court, or a subset of treaty parties. Can I just start with the VCLT? My lord, if I can ask you to turn to that, it's bundle 7. Tab 101.
Are we coming back to Mr. Hartley? Or?
No, we're not. Well, this is an example, I'm not saying this applies here. This is an example of a rule of treaty conflict and it's in the VCLT, tab 101, article 30. Paragraph 2 of that article, it's at page 3410 of the bundle, specifies a conflict rule, then it specifies, where a treaty specifies a conflict rule, then it ought to be followed. Paragraph 3 gives a rule where the treaty lacks a conflict rule. This paragraph embodies what is described as a lex posterior rule, namely that the later treaty prevails over the earlier treaty with the same parties. And paragraph 4 applies the same principle, but this time when the parties are not the same, the rule only applies to the extent there is overlap. So there are 2 points to emphasize here, my lords. First, consistent with international law, the VCLT does not speak of a treaty or provisions being invalidated or terminated in order to resolve the conflict. Rather, the rules state that the treaty is applied or disapplied to the extent needed to resolve the conflict. And as I said, I'll come back to the meaning of disapplication. But I want you to note the very deliberate avoidance of the language of termination or invalidity in the context of conflict. So when there's a conflict, it doesn't apply. It's not saying that the provision with which it conflicts is invalidated. Second, and related to the last point, VCLT Article 30 is a residual or default rule and does not contain a comprehensive set of the applicable rules of conflict. And we see this point repeated in all the texts of treaty interpretation in the VCLT. And I'm saying that to you, my lords, because you should not feel, my lords, that the only rule of treaty conflict that exists and that can be applied is in the VCLT. It is well understood in international law that this is a default rule and that there can be other rules. And that is where the rule that I say on behalf of Spain applies here resides, outside the VCLT. My lord, can I just take you to an article by one of the leading texts on this, which is by Professor von der Decken on the VCLT. It's in volume 8 of the authorities bundle. You can put away the VCLT from you.
Yeah.
And also, this is the tab 140, my lord. Apologies. It's page 4203. I wanted your lordship. What I want you to take away from this, my lord, is you'll see in paragraph 2, rules aimed at solving conflicts between treaties not only enhance legal certainty and clarity, while delimiting the rights and obligations of state parties to various treaties, they also contribute to the observance of treaties and therefore the observance of public international law. There are many rules and principles which are theoretically applicable. The most important of these are the hierarchical principle, lex posterior, lex prior, and lex specialis. The Convention, however, does not embody all of them. The lex prior and lex specialis rules have not been codified, and the hierarchical principle has been found, has only found rudimentary codification. My lord, if you then move to page 4214, which is 552, the internal page 552, bundle page 4214. It's not easy to read the bundle pages.
Yeah.
This passage, my lord, points, and this is paragraph 33, the many ways in which Article 30 falls short. That is not surprising because it would be a rather blunt instrument to say that treaty conflicts can always be resolved by chronological rules about when the treaty was passed. And my lord, if you move down to paragraph 34, this re-emphasizes that Article 30 does not give comprehensive answers. The fact that Article 30, I'm reading this now, the fact that Article 30 does not give comprehensive answers, however, does not mean that the conflicts will remain unresolved. Firstly, there are still several additional principles and techniques, either to avoid or to complement the application of Article 30. Secondly, Article 30 is residuary in character. I think it means it's a default. States are free to decide on the relationship between the diverging treaties anyway. Thirdly, a careful and detailed interpretation of treaty provisions may provide, in many cases, that there is no conflict to be solved, and thus rendering the application of Article 30 unnecessary. My lord, so what does anyway mean? So how does one find out what other rules there may be if Article 30 doesn't cover it? My lord, a good overview of the different sources of where the treaty conflict rules may be found is in one of the leading texts in this area by Dr. Akavi on the methods of resolving treaty conflicts or conflicts between treaties. And I want to take you to that. It's in the same bundle. It's tab 129. My lord, if you could turn to bundle page 4025, in the second paragraph, the parties to a treaty. You see, there says the parties to a treaty may express their intention as to the manner in which conflicts should be resolved in a form other than an explicit treaty provision. Such an intention may be expressed either in the course of the preparation of a treaty or after its adoption. My lord, page 4027, the third paragraph of Roman numeral 2, sorry, states can also regulate the relationship between two treaties by agreement. The form of such agreement is not important. It may take the form of a treaty, a declaration at the end of a diplomatic conference, a joint communique, a resolution of an international organization, and so on. What matters is that the intention to resolve the conflict should be clearly established. And then finally, my lords, if you turn to page 4028, you'll see in the opening sentence of Roman numeral 3, another way of expressing an intention on the resolution of conflicts is through subsequent practice. So, my lord, what this short overview tells us is that the relevant rules of treaty conflict are the domain of states to agree as they so wish. As long as they are clear, they can be in the VCLT, in their relevant treaty, or in some other agreement or practice, and they don't have to be in the treaty themselves. And my lord, that is precisely the situation we have in the EU context. We see conflicts ruled both in the EU treaties and in the practice of the CJEU. My lord, I was going to go to that next. I wonder if that's a good moment.
I think you're making reasonable progress, aren't you, despite losing?
I think I am, my lord, as long as you're not going too quickly.
No, it's absolutely fine.
I promise to get to Article 26, my lord.
Yeah, okay. And so we're all right sitting up or standing tomorrow?
My lord, yes.
Okay. Up or standing? Thank you.
All rise if able.